Hello everyone, I am Palak and welcome to Rostrum Legal series of most important judgments of 2022. Here we are dealing with 15 most important judgments of Constitution of India in 2020. So starting with the first case, that is Deepak, son of Lakshman Dongre versus the state of Maharashtra and others. In this case, the Honorable Apex Court has held that the order of externment from any state, district, or town, or from any particular area is cannot be passed arbitrarily and is under judicial review because it is somewhere taking away the rights, the fundamental rights of a person for right to freedom of movement under Article 19(1)(d). Moving on to the second case, that is the state of MP versus R.D. Sharma. In this case, the court, while setting aside the order of Madhya Pradesh High Court, has held that the court has wrongfully applied the principle of equal pay for equal work that can be found mentioned under the directive principles of state policy in the Constitution of India and which has taken the form of law in the Minimum Wages Act, while exercising the power of superintendence under Article 227. In another case, named as Gyanendra Kumar Singh versus the Bihar Legislative Assembly, Patna, the Honorable Court, while discussing the powers of Speaker in the 10th schedule to the Constitution of India, has held that the Speaker do have the power under the 10th schedule to decide disqualification of the members of the assembly, but the power is restrictive and the speaker cannot deny pensions or other benefits that are provided to the member of legislative assembly while deciding the disqualification plea in the 10th schedule. In another case named as Neil Aurelio Nunes and others versus Union of India and others, the court, while deciding a writ petition challenging the reservation of candidates of EWS and OBC quota in medical courses under the NEET PG courses, has highlighted as much as three guidelines in which the court has decided in the affirmative to provide reservation to OBC and EWS candidates in all India quota seats in medical and dental courses in NEET PG exam, further held that Article 15 Clause 4 and Article 15 Clause 5, they are part and parcel of Article 15 Clause 1 and are restatement of the said clause 15 Clause 1, which is providing the principle of substantial equality. The court further held that reservation is a remedy to those which are belonging to the underprivileged community and the disadvantaged groups. In another case, named as the Pharmacy Council of India versus Rajiv College of Pharmacy, the court has held that the establishment of any educational institution is a fundamental right under Article 19(1)(g) of the Constitution of India, and that right can be restricted by the authority of law by imposing reasonable restrictions, but not merely by executive instructions. The court has held that in a case Muhammad Latifi Margray versus Union Territory of Jammu and Kashmir, the court held that and reiterated the right to live a dignified life, which is available to a living person. The court extended the provision and has held that this dignified living life extended to the person when he is dead. The court illustratively held that the body of the person, when buried, is under the custody of law and it cannot be disinterred unless with the permission of the court, and the court will provide the permission only when there is an interest of justice. Therefore, the court has held that Article 21, providing for the dignified life, will extend even when the person dies. In another case, known as Venkatesh S. Venkatesh versus the Union of India, the court observed that the writ of mandamus, which is among the five writs, cannot be provided, cannot be seeked, mentioned so as to enact or amend any legislation. Therefore, the court set aside and dismissed the writ seeking amendment in the Hindu Succession Act 1956 upon the recommendation of the Law Commission of India. In another case, named as S. Rukmani Madegoda versus the State Election Commission, the court has held that the State Election Commission do have similar powers to that of the Election Commission, and it can issue directions where there is absence of law or where the particular law is silent so as to condemn the corrupt practices and to encourage free and fair election, which is a significant character of the Constitution of India, as well as which is necessary for public interest as well. In Shanavi Punuswamy versus Ministry of Civil Aviation, a leading case in which the Honorable Apex Court has provided relief to the members of transgender communities and reiterated that it is the duty of the government of India to provide equal employment opportunities to transgender persons, to the person belonging to the transgender community, as they are already victims of discrimination in various other fields, such as health and education. Moving on to another case, that is Bengal Secretariat Cooperative Land Mortgage Bank and Housing Society Limited versus Alok Kumar. In this case, the court has discussed the scope of Part 9b to the Constitution of India, which has been inserted by 97th Constitutional Amendment Act 2011 relating to cooperative society. The court has held that Part 9b would has no application on the local cooperative societies, but it do have application on the multi-state cooperative society and the cooperative societies in the union territories of India. In state of Manipur versus Buyamayam, Abdul Hanan alias Anand, the court has held that it is a fundamental right of a person who has been arrested to make representation to defend himself under Article 22, Clause 1, more particularly under Article 22, Clause 5. And the court illustratively held that If the detention authority supply blurred copies of the relevant documents on which the authority has relied to detain the arrested person, it would amount to a clear violation of Article 22, Clause 5 of the person who has been arrested. That is, it is a violation of right to make a representation and right to defend himself. In Gaurav Kumar Bansal versus Union of India, the court reiterated the ex gratia compensation claims that could be made by a person who are dependents of the person who have died due to COVID-19. And the court has provided that the claims for ex gratia relief can be made within 60 days and 90 days in case of death of the person before or after 20th March 2022. In Ashutosh Kumar versus the Film and Television Institute of India and another, the court has held that and has provided relief to the person with colorable blindness, the person who are suffering from color blindness. The court has held that FTII, that is the Film and Television Institute of India, as well as similar other institutes, should make a change in their curriculum so as to accommodate the persons with color blindness, to accommodate them in those courses, in all the courses provided by FTII as well as other institutes, so that the persons with color blindness should also go with this flow of the courses provided by certain institutes. In another case, that is Jacob Pulyal versus Union of India, the court has emphasized the right to choice, that is the part and parcel of Article 21, and has held that the right to refuse vaccination in the wake of the vaccination schemes and the vaccination campaign of the government of India, the right of a person to refuse vaccination is the right of a person under bodily integrity under Article 21 to the Constitution of India, and the person can deny the vaccination. In another case, named as Buddhadev Karmaskar versus the state of West Bengal, the court has made a very much the court has made and has granted relief to the sex workers and has directed the UIDAI, that is the Unique Identification Authority of India, to make Aadhaar cards to the sex workers based on the Proforma certificate that was issued by the gazetted officer at the National AIDS Control Organization or the project director of the State AIDS Control Society. The court further held that while in the process, the confidentiality of these sex workers should be maintained. In the very last case of this series, that is Krishna Rai dead through LRs versus the Banaras Hindu University and others, the court has held that the principle of estoppel will not apply in a selection process if that selection is held contrary to the relevant rules. The court further emphasized upon the analogy that estoppel cannot override the law and has held that if there is principle of estoppel, then there is a violation of law in the selection process. Here I am wrapping up the session, and we will meet in the next session with 15 most important judgments of Constitution of India in the next session. Thank you so much.